Okay, everybody, I'm going to do something that I have never done. We are going to listen to the deposition testimony of Jack Smith. You know, the guy. Let's see, can you see my little cursor? I don't think you can see it. Anyway, so the guy, who special counsel who was going to charged and was going to prosecute Trump for all of his crimes on January 6th and stealing documents and everything else, but never got that chance. Thanks to a lot of people who are either short-sighted or victims of extreme propaganda. I'm not sure which. But anyway, while we do it, we're not just going to sit here and stare at the screen the whole time. We're also going to play some Mega Man. Mix it up a little bit. Mega Man, Mega Jack Smith, I don't know. But anyway, yeah, I'm going to throw this out there. Maybe this will help to get somebody to maybe watch a little bit of this who wouldn't have watched it otherwise. Probably not, but we're going to try it. All right. And to start this, we are going to do Mega Man 1. I'm playing this on the Mega Man Legacy Collection, which I have on my PC. So, anyway. Yeah, that's what we're going to do. Let's get this rolling.
Mr. Brewer.
Thank you, Mr. Castor. On behalf of Lanny Brewer and myself, we do have some preliminary remarks that we would like to make. Mr. Smith is committed to providing information to this committee.
Hold on just a second there. I also would like to quickly peruse. Where is it at? We're going to, don't fall over. We're going to also use the hand-drawn game guide for Mega Man for this little run. And if you go by the order suggested, let's see who should be first. Because these bosses in Mega Man, if you find them in just the right order, their weapons just take the other ones out big time. Let's see here. So if you go by the preferred order, it looks like our first guy is going to be Bomb Man. Bomb Man. All right. I need to get me. Ooh, that'll work. I need a little bookmark. Got a little Pokemon card here. Never played Pokemon, never got into it, but my kids seem to like the cards, so I've got a little card here. We'll use that for a bookmark. Okay. All right, there we go. Now, let's get back to it. So we're going Bomb Man first, while we listen to Jack and his attorney talk a little bit. Okay, here we go.
About the work of the special counsel's office, while following all laws and rules restricting a former prosecutor's ability to disclose certain information. To that end, we appreciate the committee's assistance in working with the Department of Justice to provide Mr. Smith with authorization and clarification on the parameters around Mr. Smith's testimony today. Of course, some restrictions remain on Mr. Smith's testimony, two of which I would like to highlight before we begin. First, as the committee is aware, in its letter of December 11th, 2025, the Justice Department admonished Mr. Smith that he is not authorized to divulge information that is prohibited by law or courts, including that which is subject to Federal Rule of Criminal Procedure 6E. It is our understanding from communications with the committee and the Justice Department that DOJ is interpreting a matter under Rule 6E to be limited to the inner workings of the grand jury. On a call with committee staff and with the Department of Justice on December 11th to discuss the scope and application of grand jury secrecy requirements, Assistant Attorney General Patrick Davis agreed with Mr. Castor's statement that based on DOJ's authorization letter and its interpretation of Rule 6E, it would be virtually impossible for DOJ to prosecute Mr. Smith for violating grand jury secrecy restrictions. Second, according to the Justice Department, discussion of Volume 2 of the Special Counsel's report and any information or conclusions in Volume 2 or in drafts thereof is specifically prohibited by Judge Cannon's January 21st, 2025 order. This morning, just over an hour ago, the Department of Justice sent us an email affirming its view that Judge Cannon's order applies to Mr. Smith and that it precludes him from disclosing any non-public information that may be contained in Volume 2, including, but not limited to, interview transcripts, search warrant materials, business records, toll records, video footage, records obtained by grand jury subpoenas, attorney-client communications, and potential Rule 404B evidence. This restriction significantly limits Mr. Smith's ability to discuss the classified documents case. Nevertheless, Mr. Smith is committed to doing his best to answering questions consistent with the department's guidance. And I ask that that email from the Department of Justice that was sent earlier this morning be made part of the record.
That'll be Exhibit 5.
Thank you. I also want to clarify that the email from the Department of Justice says that Mr. Smith can disclose information in answering questions where that information is in the public record and has been made publicly available through authorized means.
So in case you're unaware, when Jack Smith filed his final reports shortly after Trump had been elected, but before he took office, at least I'm pretty sure it was right then, because it was days after Trump got in office before he dissolved the special counsel. But he filed it in 2 reports. One of them had to do mostly with the January 6th case, and the other one was mostly all the conclusions and evidence and timeline and everything involved with the Mar-a-Lago case with the stolen documents and the stolen classified documents. I believe, if I'm not mistaken, it was the classified documents case that Judge Cannon in Florida said should remain sealed, whereas the other one was opened and made public like every other special counsel report has been done. So the question is, why are they keeping it sealed? Why are they keeping it secret? Why won't they let him talk about it? Why won't they let this all happen in an open hearing, like when the special counsel that was investigating Hunter Biden's son, Hunter Biden, was all laid out in the open and in public? You know, it's because they're all lying scumbags and they're trying to cover their tails best they can. But, you know, you're welcome to not have your own conclusions, I suppose, and if you want to.
And I want to specifically cite that language because yesterday, the Department of Justice disclosed to Senator Grassley some emails related to the execution of the search warrant at Mar-a-Lago. I anticipate that those emails may be used during today's deposition and that Mr. Smith may be asked questions about that search warrant and the probable cause supporting the search warrant that was signed by a judge in the Southern District of Florida. And I just want to confirm our understanding that because those emails were released by the Department of Justice to Chairman Grassley, everyone here has a mutual understanding that those emails were made publicly available through authorized means.
And we would concur with that. In our discussion with the Justice Department, and it was in the context of the member toll records subpoenas, they indicated that documents that are in the public realm are fair game for discussion and don't apply to the 6E prohibition, the disclosure of 6E material. And we would further acknowledge that if Senator Grassley posted these materials on his official website, that is an authorized release. I mean, these are materials that were produced to the House and the Senate, and if Senator Grassley posted them publicly, they are certainly part of the public record.
Thank you, Mr. Castor. We are in agreement.
Mr. Castor, can I just note one thing for the record, that counsel for the minority have not been involved in any of the discussions that Mr. Koski just discussed between the Judiciary Committee and Department of Justice. I just want to make that clear for the record.
All right, noted.
Thank you. My understanding is that if, for whatever reason, the questions today move into an area that we believe Mr. Smith cannot answer because of some legal restriction, we have reached an agreement with the committee staff that we will raise our concern in the moment to see if we can navigate around the restrictions. And if we are unable, we will move on to another topic and then revisit that issue during a break or at the end of the day. Yes.
Just to augment what my partner said, we had proposed to the Department of Justice that it have a lawyer here present today, so that if any issue came up, we could immediately resolve it, because Mr. Smith is committed to answering every question he can lawfully. The Department of Justice chose not to have a lawyer here today.
Thank you. Finally, I feel compelled to make an observation about the risks of participating in this deposition. The most powerful person in the world has said that Mr. Smith should be in jail because of his work as special counsel. Not because Jack did anything wrong, but because he had the audacity to follow the facts and the law and apply them to that powerful person. And through its actions, this Justice Department has demonstrated its eagerness to follow President Trump's orders, despite the facts and the law. Yesterday, the President's Chief of Staff is reported to have confirmed in interviews that the President is indeed pursuing criminal prosecutions against his perceived adversaries as part of a retribution campaign. In the face of those threats, Mr. Smith appears today undaunted, comforted by the knowledge that not only did he do nothing wrong, he conducted his work as special counsel with integrity, impartiality, and an uncompromising commitment to the rule of law. If the committee will allow, Mr. Smith has some remarks that he would like to share.
Okay, before that, I would just note from Exhibit 4, the December 11th Justice Department letter, they specifically say, at the last paragraph on page 2, as to your question about the department's recent disclosure to Congress of certain internal communications considering whether to authorize toll record subpoenas, which Congress publicly released on November 25th, 2025, you are correct that the department does not believe that the specific materials it produced to Congress are covered by 6E for the reasons described above.
Thank you, Mr. Castor. That's helpful. We are in agreement on that. My concern is that that doesn't address Judge Cannon's order, which the department has said Mr. Smith is still bound by because the toll record subpoenas were not part of the classified documents case. And so Judge Cannon's order is a separate legal restriction that exists independent of Rule 6E.
Okay. And I would just note on our call with the Justice Department, their position was, of course he can talk about it if it's in the public realm. And that admonition from the department was not limited to the toll records question or something in Judge Cannon.
Thank you.
Mr. Smith, you have some remarks as well?
Yes, thank you. Thank you for the opportunity to discuss my work as special counsel. I was taught as a young prosecutor to follow the facts and the law, and to do so without fear or favor, to do the right thing the right way for the right reasons. For nearly 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors, FBI agents, and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs.
Absolutely.
I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial.
Scribe is how you stop explaining the same thing over and over.
Come on,
Watch
dude.
this. It'll change.
With that.
If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
Just so professional.
We can get you a copy. Yeah.
I couldn't be that professional.
You just made some pretty definitive statements about, your belief that President Trump was guilty of these charges. Is that correct?
Yes, I believe we had proof beyond a reasonable doubt in both cases.
And doesn't the Justice Manual prohibit prosecutors from asserting that a defendant is guilty of something before a jury makes a determination?
When a case is pending, yes.
Okay, and so you think you're free from that, from the Justice Manual rules, once a case is dismissed?
No, I think that it's important to state clearly the amount of evidence we had and the basis for why we proceeded. Why we proceeded as we did is because we had a strong case, as I set forth in the final report.
Right.
What kind of stupid ass question is that? Don't you think it? are not supposed to have an opinion about whether or not this person's actually guilty or not. He's a prosecutor. He's not supposed to bring a case unless he believes there's clear evidence that he can get a conviction beyond reasonable doubt. So yes, he has to believe that he must be guilty. Oh my God. Oh. These people.
But your final report makes what seems to be conclusive determinations of President Trump's guilt, as opposed to laying out simply the facts and the evidence that you have. I mean, you draw those conclusions that, in your view, he's guilty. Is that not the case?
Well, to be clear, the cases were never tried. We were never put to our burden before a jury, so we didn't conclusively prove it. The reason the report was written the way it was written, and the reason I said what I just said, is because it was our belief that if we went to trial, we would prevail.
But your report differs, you know, if you look at Special Counsel Herr's report and Special Counsel Mueller's report. I mean, the language that you use and the way you describe the things that you believe President Trump committed, you know, is different. You know, Herr was careful to use words like jurors could find or might, at most, would likely conclude, whereas the language you use is pretty definitive.
The Herr report states his assessment of the evidence. Mine does as well, and as I said, I feel and feel to this day that we had a very strong case, and so I communicated that.
Okay, but you would agree that it's the role of the jury, not the special counsel, to weigh the facts and determine guilt?
Ultimately, yes.
And then one other thing about relating to your statement, and we'll get into this a little later on, but the toll record subpoenas for members of Congress, you know, we have some very serious concerns about acquiring these toll records, you know, relating to senators and members of the House. I mean, members of the House and the Senate have protections under the Constitution that you know, allows them speech or debate protections. And the toll record subpoenas, in our view, and if we had to litigate it, you know, the House lawyers would take the position that those toll record subpoenas violated the speech or debate protections. And is that something you disagree with?
Yes.
Okay. And we'll get into that a little bit later. We first wrote to you on October 14th, inviting you to
we would argue that violates that. Is that something that is that something you would contest? Yes. Oh, okay. We'll get back to that later. God. I mean, who is this stupid idiot asking this question?
to testify. And then we worked with the Justice Department and your counsel to make sure you had access to everything you needed to prepare for today. Did that occur? Did you have enough access to the information you need to prepare?
Yes.
Okay, so we asked the Justice Department to make all your files available, to allow you to go to the Justice Department whenever you wanted to, with your lawyers, whoever you wanted to. And I just wanted to confirm that you had the opportunity to review whatever you needed in your files before today.
Yes, we reviewed the files.
Okay.
That's correct.
There might be an issue with classified materials. We don't intend to ask you anything about anything classified. Obviously, if your security clearance is no longer valid, there's an issue on that front. But everything except classified information was supposed to be made available to you, and I just want to confirm that that was the case.
I'm not sure if everything was. For example, the emails of people on my staff. I'm not sure I had access to that, but we did spend, consistent with what you said, time at the Department of Justice, and we had the opportunity to review files.
And that access was made available early, like November 10th, if I'm not mistaken, and I think you guys started reviewing it somewhat shortly thereafter.
That sounds about right.
Okay.
And to get this,
You
to
have referenced in your pleadings, I believe, and also in public statements you've made, the famous Robert Jackson speech entitled "The Federal Prosecutor" that he delivered at the second annual conference of the United States Attorneys in 1940. You're familiar with the Robert Jackson speech?
I am, yes.
Okay. And this is widely available on the internet. I didn't make copies for everybody. Everybody can Google it right now as long as your phones are working. And I'm just going to flag some things that Robert Jackson said and just get your reaction to see if you agree with it or not. He says in the second sentence, "The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous." Do you agree with that?
I agree that prosecutors have a lot of discretion, yes.
Jackson stated, "While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst." Do you agree with that?
I do.
On page 4 of his remarks, in the penultimate paragraph, Attorney General Jackson states, "What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain." Would you agree with that?
Yes.
If a prosecutor is obliged to choose his cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get, rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it's not a question of discovering the commission of a crime and then looking for the man who committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offenses on him. Do you agree with that?
I do, I think, yes.
Okay. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. Do you agree that that is a concern?
These are principles, and I agree with these principles.
Okay. In times of fear or hysteria, political, racial, religious, social, and economic groups, often from the best of motives, cry for...
I mean, he's just sitting there like, what the hell does this have to do with anything that I did? Are you saying that I didn't do all this, I guess? I mean, do you have an actual question of anything I did? Or do you want to just sit here and read some attorney's opinion once upon a time that's in a law textbook? I'm surprised he's not scratching with his middle finger right there, honestly.
For the scalps of individuals or groups because they do not like their views. Do you agree with that?
Yes.
He concludes by saying the qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you agree with that?
Fully.
And do you think during the pendency of your special counsel work that you tried to live up to those standards?
I do.
Was there ever a prospect after you were appointed special counsel when you thought maybe you would not bring an indictment against President Trump?
Absolutely. When I took this case, I did not know enough about the facts or the law to have a judgment about whether we should proceed in either case, both cases, or neither case. I used my time when I was appointed to get up to speed on the facts and the law. But if the facts in the law did not justify going forward in this case, I would have been perfectly comfortable in doing that, as I have throughout my career in cases involving political figures when I was in public integrity and throughout my career. So I did not have a preconceived outcome in mind when I took this job.
Was there any point where you and your prosecutors that formed your team debated not bringing charges against the president?
Of course. I mean, that is the process of being a prosecutor, is you are analyzing evidence, you're collecting facts, and you're debating whether it's what the facts mean, the inferences to be drawn from the facts, or debating what the law is, and whether you can prove what you think is happening here or not. And so that was a continual process to decide
This
if
guy
in fact we
cannot be
could
asking serious
go forward.
questions.
And that, and again, just to be clear, that is a process that I have undergone in my career personally and with prosecutors I've supervised.
When was the decision made that you believed you needed to move forward with both indictments, both in Florida and DC?
Well, so the decision wasn't made at the same time. To the best of my recollection, in both cases, the final decision was shortly before we sought indictment.
Okay. In June of 2023, you had a meeting with the
At least
Attorney
there was an
General
actual
to
question with
present
an answer. That had an
a
answer.
prosecution memo and basically asking for his blessing to bring the indictments. Is that correct?
We did have a meeting, and I think it was around that time. I didn't think about it as his blessing. I was presenting what I intended to do, and he had the ability to countermand that if he wanted to.
Okay. But certainly, you couldn't bring an indictment without his authorization.
He could block me from doing that, that's correct.
Okay. And during that June 2023 meeting with the Attorney General, did you guys discuss both indictments, potential indictments, or just the Florida indictment or just the DC indictment?
If it was, I don't have a specific recollection of dates, and so you can check me on public records, but I believe by late June, the classified documents case had already been indicted.
Okay.
So again, this is my recollection, but that would have been, a discussion in late June would have likely been about just the elections case,
Okay.
if it was about an indictment.
Okay. And the Attorney General in the June meeting, it's been reported that he expressed some reservations about the DC case. Is that correct?
I had several meetings with the Attorney General about both cases, and in those meetings, we regularly discussed legal issues, factual issues, things of that nature. Never in those meetings did he tell me I couldn't or shouldn't go forward or should go forward. It was more talking through with another experienced lawyer the legal issues present in the cases, as well as if I was going to go forward, how to best frame those.
Okay. Coming out of the June meeting, it's been reported that he asked you to spend some time with the Solicitor General to review the DC case. Is that correct?
Again, I don't recall specific conversations. What I can share with you is we consulted with the Solicitor General regularly during my time as special counsel. That was a choice I made. We wanted to make sure not only that we got the facts right, but that we got the law right as well. And so
I don't think it gives me extra energy.
I would be surprised if the first time I consulted with the Solicitor General would have been in late June. That would surprise me.
Okay. But you did have a one-on-one meeting with the Solicitor General in person?
I've met the Solicitor General in person. My recollection is most often it would be members of my senior staff speaking with her staff about these legal issues. I did have conversations with her as well, but the majority of that was her staff and my staff speaking about things.
Okay. And as it's been reported, the Attorney General at the time was concerned that the proposed indictment or the proposed prosecution plan, may have relied too heavily on statements that the president had made and infringed on his free speech if you were going to prosecute him for it. Is that fair?
As I sit here right now, I can't remember specific conversations. I do remember that we knew that a sort of First Amendment defense would be part of the case. And I think when I mentioned to you earlier about how to frame the case, we wanted to make clear that this was not about trying to interfere with anyone's First Amendment rights, that this was a fraud. And as you know, under Supreme Court precedent, fraud is not protected by the First Amendment. And so in my mind, it was important to make that clear in the indictment. And that's why when we litigated this issue before the district court, we prevailed.
But the president's statements that he believed.
That's right. Because if what he was doing was a fraud, and if everything he said and everything he did was in commission of that crime, then it is not First Amendment speech. It's not protected. Just like you can't yell fire in a crowded theater when there's no fire. A lot of people can get hurt. It can be loss of property, blah, blah, blah. Some people think that, oh, anything you say is protected by the First Amendment. No, it's not. Not anything you say. Not anything.
The election was rife with fraud. Those certainly are statements that are protected by the First Amendment, correct?
Absolutely not if they are made to target a lawful government function and they are made with knowing falsity. No, they're not. That was my point about fraud not being protected by the First Amendment.
I mean, there's a long list of disputed elections. I mean, the election of 1800, 1960, year 2000, where candidates believe they were wronged by the, because they lost. And there's a long history of candidates speaking out about they believe there's been fraud, there's been other problems with the integrity of the election process. And I think you would agree that those types of statements are sort of at the core of the First Amendment rights of a presidential candidate, right?
There is no historical analog for what President Trump did in this case. As we said in the indictment,
yeah, none of that is the same as what happened here. Here's the apple of what happened, and let's compare that to the semi-truck you think is the same.
he was free to say that he thought he won the election. He was even free to say falsely that he won the election. But what he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. Mm-hmm. That he was not allowed to do. And that differentiates this case from any past history.
A lot of these statements, though, you know, people come into the Oval Office. I mean, the president isn't conducting his own due diligence. He is receiving people in his office that are telling him these things, whether it be Rudy Giuliani, whether it be John Eastman, whether it be Jeffrey Clark, whether it be Sidney Powell. And, you know, for the most part, he is just receiving this information and, you know, his statements are almost just regurgitating what these people have told him. I mean, isn't that the case?
No, and in fact, one of the strengths of our case and why we felt we had such strong proof is our witnesses were not going to be political enemies of the president. They were going to be political allies. We had numerous witnesses who would say, I voted for President Trump. I campaigned for President Trump. I wanted him to win. The Speaker of the House in Arizona, the Speaker of the House in Michigan. We had an elector in Pennsylvania who is a former congressman who is going to be an elector for President Trump, who said that what they were trying to do was an attempt to overthrow the government and illegal. Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so The president got information from people he trusted on other issues. He rejected it whenever it didn't fit him staying in office. And there was a pattern in our case where anytime any information came in that would mean he could no longer be president, he would reject it. And any theory, no matter how far-fetched, no matter how not based in law, that would indicate that he could, he latched onto that. And we were confident that we had very strong proof of that pattern. He also, I would just add, very consciously did not try to reach out to the sort of people who have the most expertise on these issues. He reached out to people who he thought could back him up.
Yeah, but let's be honest. The president doesn't reach out to anyone. People are brought to him. I mean, he doesn't, like, the people you mentioned that you were going to call a trial, those aren't, some, Pennsylvania Republican official. I mean, that's not somebody who was in the Oval Office communicating with the president.
Well,
right?
Well, with respect to the Arizona Speaker of the House, that is someone the president reached out to. He also reached out to governors. He reached out to the governor of Arizona. He reached out, and again, Republicans, his allies. Our case
Georgia?
Was a case in which the president was preying on the party allegiance of people who supported him. And these are, again, the record is rife with examples of him reaching out to those people, inviting them to the White House. And another example, sir, is the folks from Michigan. He invited them to the White House. They told him, you lost because you underperformed with educated females. They told him that when he brought them there. And again, our case was filled with examples of that.
Were you planning on calling John Eastman as a witness?
I do not believe we would have, but we would have welcomed if the defense called him.
Okay. It gets tricky, though, for the defense to call him because the people like Eastman and Clark and, Rudy Giuliani and Sidney Powell, I mean, they were shrouded by the special counsel as, co-conspirators 1 through 6. And so they all feared that they were going to be prosecuted if they said anything. Isn't that fair?
Well, they were co-conspirators. I can't get into what was in their mind or not. I can tell you some of the co-conspirators met with us in proffers and did interviews with us. And so the idea that someone like Rudy Giuliani, who sat with a proffer for us, he was available as a witness, and we would have welcomed President Trump calling him as a witness. Boris Epstein sat for an interview with us. We would have welcomed calling him as a witness. Kenneth Chesborough, we would have welcomed it.
Why didn't you?
We were going to call them ourselves, but if they were dumb enough to get up on the stand, yeah, we've been fine with that. Oh my God.
Did you charge any of those folks?
I'm sorry?
Why didn't you charge any of those co-conspirators?
As we stated in the final report, we analyzed the evidence against different co-conspirators. My staff determined that we did have evidence to charge people at a certain point in time. I had not made final determinations about that at the time that President Trump won re-election, meaning that our office was going to be closed down.
Right. You've had a 30-year career as a prosecutor. You've prosecuted gang members, right?
Yes.
You've prosecuted organized crime members, right?
Not as much.
But, surely one of the, fundamental principles of prosecutorial work is you work from the bottom up and you try to get as many fact witnesses to work with you. And a lot of times those fact witnesses have criminal liability. And a lot of times those lower fact witnesses, the smaller fish, are almost always they're either prosecuted or they are given an immunity because they fear they're going to be prosecuted. But here you didn't, you kept laser focused only on President Trump.
2 points. One, as I said, we were considering prosecutions of these people, and I think, I don't want to say what the ultimate conclusion would have been, but that was something that was being considered. The second thing, I think, to understand contextually is this was a case where the issue was how to present it in a concise way. We had so many witnesses, again, so many witnesses who were allies of President Trump available to us to testify. This was not a case where we needed more witnesses. It was a case where we needed to be able to present the case in a streamlined way because there was so much evidence.
In this book by the Washington Post reporters on page 310, you're familiar with this book. Have you read it? It's called Injustice by Lenig and Davis.
No, I have not read it.
Are you familiar with it?
I have not seen it. I mean, I saw that it came out in the news, but I have not read it.
Okay. Did you cooperate with the book? Did you talk to Carol Lenig or Aaron Davis?
They reached out to my counsel. I did not speak to them.
And did you ever speak with them during your tenure at the Justice Department?
No.
Anyway, they report, and these are reporters. They get some things wrong. They called Chairman Jordan the chairman of the Senate Judiciary Committee. They said Speaker McCarthy voted in favor of the second impeachment, and I can confirm that it's just laughably inaccurate. And so reporters get things wrong, and so if that's the case, please flag it. But in the book on 310, the reporters write, as each new tranche of information about fake electors came in, members of Smith's team intermittently raised the idea of opening separate case files on Giuliani, Eastman, and others. Each time, however, Smith dismissed the idea. He said he did not want the office getting bogged down and potentially prosecuting those around Trump. Is that?
I don't think that's accurate. I did make the decision that the first case we brought was going to be Donald Trump, and I was aware that there was evidence against other people, but I don't think that characterization is accurate.
Okay. Now, people with different views than you can say the special counsel's office is only interested in prosecuting President Trump because an election's coming up and he's going to be the Republican nominee, and the special counsel works for a Democratic president. The special counsel works for a Democratic attorney general, and so the special counsel's laser focus on President Trump is simply to prevent him from, either being the party's nominee or being a successful party's nominee, or at the very least, keeping him off the campaign trail. How do you respond to that?
All of that is false, and I'll say a few things. The first is the evidence here made clear that President Trump was, by a large measure, the most culpable and most responsible person in this conspiracy. These crimes were committed for his benefit. The attack that happened at the Capitol as part of this case does not happen without him. The other co-conspirators were doing this for his benefit. So in terms of why we would pursue a case against him, I entirely disagree with any characterization that our work was in any way meant to hamper him in the presidential election. I would never take orders from a political leader to hamper another person in an election. That's not who I am, and I think people who know me and my experience over 30 years would find that laughable.
So did you develop evidence that President Trump was responsible for the violence at the Capitol on January 6th?
So our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him.
But you don't have any evidence that he instructed people to crash the Capitol, do you?
As I said, our evidence is that he, in the weeks leading up to January 6th, created a level of distrust. He used that level of distrust to get people to believe fraud claims that weren't true. He made false statements to state legislatures, to his supporters, in all sorts of contexts and was aware in the days leading up to January 6th that his supporters were angry when he invited them, and then he directed them to the Capitol. Once they were at the Capitol and once the attack on the Capitol happened, he refused to stop it. He instead issued a tweet that, without question in my mind, endangered the life of his own vice president. When the violence was going on, he had to be pushed repeatedly by his staff members to do anything to quell it. And then even afterwards,
I remember that.
he directed co-conspirators to make calls to members of Congress, people who were his political allies, to further delay the proceedings.
Did you sought gag orders in both the Florida case and the DC case, is that correct?
We sought an order in the DC case under Rule, I think it's 57.2, and we did that because Donald Trump was making statements that were endangering witnesses, intimidating witnesses, endangering members of my staff, endangering court staff. As you might remember, in the right around when the indictment was released, he issued a tweet saying, "If you come after me, I'll come after you." He called, in a tweet, he called General Mark Milley a traitor and mentioned that what he'd done in olden times, people would be put to death. As a result of the things he was saying, the judge in this case was received vile death threats. And with respect to DC, both the district court and the Court of Appeals, a panel of judges, found that his actions were in fact causing what we said they caused. They were causing witnesses to be intimidated and endangering people. And I believe it was the Court of Appeals also found that in addition to intimidating or chilling witnesses who existed, it would chill witnesses who had not yet come forward because they'd afraid that they would be next. So yes, we did file that, and I make no apologies for that.
I mean, which witnesses do you think he would have intimidated? I mean, are there any specific witnesses did you identify for the court?
We did a filing. I don't recall the specifics in that filing right now, but as I said, one of the issues from my perspective was not only the witnesses who he had specifically called out and caused threats to be issued, this phenomena that was found by both courts. It was the result of that is that a rational witness who maybe had not come forward would be completely afraid to, because they would see that they would be next. And I think both courts agreed with that.
Well,
Because it's no different than a mobster. If you have a mobster who's putting out all kinds of suggestions and threatening statements and, oh, if you come after me, I'm going to come after you. You know, if anyone says snitches on me, and they're going to be next. Oh, but he has a First Amendment right to say whatever he wants, you see, because he a president, he a white man, and he rich, so he gets to say whatever he wants. No, Buttercup. That ain't how it works. A-holes.
I mean, the Circuit Court of Appeals ultimately slimmed down the gag order, isn't that correct?
It did, yes.
And what was the difference between the gag order you proposed and Judge Chutkan agreed to, and the final gag order that the DC Circuit approved?
Okay, I'm going to go off my recollection. I know one of the differences was him making threatening statements towards me personally was was allowed. I think in the district court in our application, we thought that shouldn't be allowed. I will share with you that I told my staff that it was much more important to me that he not be able to issue threats to court staff and my staff than me. And so the Court of Appeals did narrow it in that way. And as I'm sitting here now, I'm not debating you that they narrowed it. I just can't remember the specific details.
Okay.
But the phenomena, they concurred that the phenomena I'm describing to you today was real. And
Okay.
it had real world consequences.
18 United States Code 1512 here deals with tampering with witnesses. Did you identify any violations of 18 USC 1512?
We did not bring any charges.
And did you allege that he violated any terms of his release?
We did not.
I want to turn to the member toll records topic.
Okay.
What's the difference between a subpoena?
So for the Yellow Devil, I don't want to go through this level a bunch of times. So if we'll try to beat him without the glitch, but if we can't get it to work, then I'm going to glitch him. I mean, hey, that's how they told you to do it in Nintendo Power back in the day, so that's how we're going to do it.
Subpoena for toll records and a 2703D order.
Well, a subpoena for toll records is non-content. Doesn't have any content, doesn't have like the header of, say, an email, things of that nature. Whereas I think if I'm correct in the terminology, I think a 2703D would be regarding emails and could have information like that.
Could have content?
Well, at least, again, this is my recollection. I haven't looked at this issue in some time, but I think it means it's not content, but it could at least have, say, the header like of the message, like not the content of the message, but it might include the header.
Did you use any 2703D orders on members of Congress or senators or their staff?
I do not recall that at this time.
Did you use any pen registers? Like, maybe just walk us through what a pen register is and trap and trace.
Yeah, my understanding or my recollection is a pen register or trap and trace is a thing where you're watching who someone's calling going forward. Like, so, if there was a trap and trace on my phone, it would see going forward from today who I called. And a pen register, I'm mixing up the terminology, but one is like calls in and the other one's calls out.
Okay. And did you use any of those techniques on members of Congress, senators, or their staff?
I don't recall anything like that.
Okay. And when you say you don't recall, it's you think the answer is no, but you don't. You're not able to give a definitive answer?
Yeah, I have nothing in my memory that tells me that we did anything like that.
Okay. And so with the toll record, so as it relates to members and their staff and senators, it's just the toll records as far as you remember?
That's my recollection.
Okay. And
well, I'm sorry to interrupt you.
Yeah.
Before I was special counsel, the people who were working on one of the investigations did get a search warrant for the cell phone of one Congressman
Perry. Yes, we are very familiar with that.
We're very familiar with that.
With the toll record subpoena, maybe just walk us through like what you get. You get the incoming, the telephone numbers that call a particular cell phone, right?
That's correct.
And you get the time that the call occurred.
Yes.
And you get the length of time of a call.
I believe that's correct.
Okay. And you also get the list of numbers that the outgoing. You get the incoming and the outgoing, right? That's
correct.
And is there any other information that the toll record subpoenas provide?
That is the what I understand is the major thing you're seeking to get with the toll records.
Okay. And when you get one of these subpoenas, you just send it to the carrier, correct? It doesn't involve the judge.
The subpoena? Yes, that's correct.
Okay.
Doesn't require a judge.
The only time a judge gets involved is if you're seeking a non-disclosure order, is that right?
If it's a subpoena for toll records, that's correct.
Okay. And do you always seek is it the practice of your team to always seek the NDO?
Well, in this particular case, there was a grave risk of obstruction of justice, given the obstructive conduct of President Trump as is set forth, for example, in the indictment in Florida. President Trump tried to obstruct that case in multiple ways. As I mentioned earlier, in the litigation we had regarding 57.2, we had numerous instances of him attempting to, in our view, intimidate witnesses or keep them from cooperating. And so given that reality, we did seek non-disclosure orders for the toll record subpoenas you're talking about.
Okay. And ordinarily you just go to, how do you pick your judge for that when you're seeking the NDOs? Some of them were signed by the chief judge, and then others were signed by a Magistrate Judge David Baker, at least as it relates to the members. How do you pick the judge? Or do they pick it for you?
I don't know that we picked the judge. I have to say, in my role in this, I wouldn't have known that. I don't know that even a prosecutor can pick the judge, but I don't know what local practice in Washington D.C. would be on that.
I mean, sometimes I think Boasberg signed the NDOs for the senators, and then as it related to Speaker McCarthy and some of our members from the Judiciary Committee, it was the Magistrate Judge David Baker. And so you don't have any idea why the...
Well, a common practice in my experience as a prosecutor, certainly when I was a prosecutor in Brooklyn, is there'll be a duty judge or a duty magistrate, and so whoever has duty that day is who you go to. I just want to be clear, in this case, I don't have a recollection if that's how it works in D.C., but it may well have been that way.
Okay. And these NDO orders, at least the ones we've seen, are all the same. Is that a fair statement?
I think they're usually very similar, yes.
Okay.
So he's bringing up Boasberg because they got beef against him, because he's trying to investigate contempt charges on the government related to some of the Venezuelan, or were the Venezuelan? Anyway, some of the immigrants that were taken to the CCOP prison in El Salvador, even after he ordered them to turn the planes around, they kept going. So that's why they're bringing that name up. They're trying to link things. And he's acting like a stupid idiot. The guy asking these questions. He's like, so do you take it, you just pick your judge? You went to Boasberg, right? That's what you did because you knew he would do what you wanted to do. And so you just went to him. No, you didn't do that. Oh, they know. There's such a waste of time.
And you submit a proposed order, correct, for the judge to sign?
That's correct.
And part of the language in this states that the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution, destruction of or tampering with evidence, intimidation of potential witnesses, and serious jeopardy to the investigation. Is that something you remember?
Yes, those are the in the law, and the numbers escaping me right now, but in the law that sets forth the reasons why you could get a non-disclosure order, I believe those are the different prongs, if you will, of that statute.
As it relates to members of Congress and senators and their staff, definitely their staff as well, I mean, that presents concern that we don't have an opportunity to quash the subpoena. How does your office deal with that prospect?
Well, the nature, and I should also be clear that when you're getting an NDO, say for toll records, it's not based on an allegation that necessarily the person who has the phone number is personally going to obstruct the investigation. It's that if this gets out, people could obstruct the investigation. So I want to make that clear. Second point would be, you are correct in that inherent in getting an NDO is that at various times, people who might have arguments about why to quash a subpoena won't be able to make those arguments. In our investigation, this came up with Twitter. We wanted to get records from Twitter regarding President Trump. Twitter, and we applied for an NDO from the judge. Twitter refused to provide the records unless they could tell President Trump about that. And so we had litigation with this in the district court. The district court agreed that there are situations, and there it was that Twitter argued that President Trump should be able to assert executive privilege over the records we wanted. And as a result of that litigation, the district court found that it was proper of us, given the level of obstruction in this case, to get that NDO. That decision by the district court was upheld by the Court of Appeals. And then that decision by the Court of Appeals, Twitter, my recollection is Twitter sought to get the Supreme Court to overrule that, and Supreme Court refused to. And so I tell you all that to say.
And then you find them, right?
Well, actually, that's before. They refused to comply even after she ruled, and she set a schedule of fines, and so part of the appeal was.
You sought the fines, right?
Absolutely, yes.
Okay.
But the point of telling you that was that inherent in an NDO is it may be that certain arguments about why a subpoena should be quashed can't be made. So that happens, and I think there's a parallel in those situations.
When it comes to members of Congress, though, there are the speech or debate protections, which you totally sidestep. I mean, the toll records provide enormous, valuable information because it shows who a member of Congress, who a senator is taking calls from, and who they're calling. And if you map it up against the Senate or the House calendar, you can see what the inputs are to their legislative decision making, which is at the core of speech or debate. Do you agree with that?
My office and I personally take the protections of the speech or debate clause seriously. I think they're part of our Constitution. They're an important part of separation of powers. I think our respect for the speech or debate clause is evidenced by the litigation we engaged in this office. We conducted litigation with Congressman Perry and also Vice President Pence, taking that very seriously. And I would just also add that my office had folks who were really the department experts on speech or debate. And when we sought these subpoenas, we got approval from Public Integrity, who are the sort of keepers of that issue. Yeah. And they concurred in us getting these subpoenas.
They did, and we saw some of that email traffic, and I would respectfully disagree with their view of the speech or debate law, as you might imagine. When you sought these non-disclosure orders, the judge didn't know it was a member of Congress. Is that correct?
I don't think we identified that because I don't think that was department policy at the time.
And you had some litigation substantial litigation with Congressman Perry over the seizure of his phone, but you didn't have any litigation with us over the seizure of members of the Judiciary Committee's phones because we never knew about it.
That's correct.
Sorry, I just want to clarify. I think you said regarding the seizure of any senators' phones?
Representative Perry had his phone seized.
Yes, but are you suggesting that there's a seizure of a senator's phone?
No.
Okay, I just wanted to clarify that. Thank you.
The only seizure I'm aware of is Congressman Perry. Do you know of any other seizures?
That's the one I recall.
Okay. So no.
So for fighting your copy here, the book recommends to use the fire beam attack because it has that little shield around it just in case he jumps into you. The shield can kind of help do damage. So that and the electric beam, just FYI. Anyway, back to this guy moaning about, oh, there was an investigation because you thought that maybe these people were involved with fraud, and so you had to investigate them and look at their phone logs. Oh, we're so violated. Oh, woe is us. Go change your underwear.
No other members of Congress, no other senator had their phone seized?
I don't.
Did you seek search warrants for the content of any, of the telephone calls, or the content relies mostly to text messages? Did you seek a search warrant for the content of any text messages from members?
From members? No, I don't recall
Okay,
that.
it was just toll records.
Correct.
Okay. But by not telling the members, by going through this NDO process, I mean, they didn't have an opportunity to litigate the speech or debate concerns.
That's correct.
And that's unfair, in our view.
I understand your position, and as I said before, we respect
See what I mean?
the speech or debate clause.
that's not
I'm aware
fair.
of no
That's not
case in the
fair.
Supreme Court or the DC Circuit that says that getting non-content toll records from a third party violates the speech or debate clause, particularly where, and I think an important point here is these records were not sought to use against members of Congress who were targets. The investigation we were conducting was of President Trump and his co-conspirators, who were all obviously not members of Congress, but also private, not even members of the White House.
I mean, the House and DOJ has a big disagreement on this. I mean, the William Jefferson case, you familiar with the Rayburn House Office Building case?
I am.
Okay. And so when issuing grand jury subpoenas for toll records, do you consider yourself bound by that opinion?
Yes, but I would say that opinion does not deal, that isn't a case where there was a search warrant of a congressman's office. That congressman was a target of the investigation. The search warrant wasn't seeking non-content toll records. It was seeking the actual records, legislative material of the congressman to be used against that congressman.
Right. But, I mean, the court in the Rayburn case concluded that there is a documentary non-disclosure privilege, not just a prohibition on the evidentiary use of that material against members.
I'm not debating the Rayburn case exists. What I'm saying is in the Supreme Court or the DC Circuit, there is no case that says non-content. Rayburn dealt with content. Non-content records, not secured from a member, but secured from a third party, are subject to the speech or debate clause. And if I may, the correspondence we talked about, that reading, which was the reading of my staff who are very familiar with this, was consistent with the department's position on those issues, and public integrity, which was sort of the keeper of this issue, concurred in our getting these subpoenas.
We're making exhibit, we have to number 6?
Yes.
And this is some back and forth. What Exhibit 6 is going to be an email between your office and Public Integrity regarding the Senate, the toll records for the senators.
Thank you very much.
Thank you.
Thank you very much.
They're hard
relevant.
up about these phone calls. They're hard up about it.
These documents are helpfully not based.
Yeah. If you want to show me
mean,
yours, I can look for it here.
I mean, nothing about, legitimacy of his prosecution or I don't know. Nothing about You know, why'd you ask this person this, that person that? Don't you think this is outside the bounds?
So
I
the
mean,
department
this is
has,
all about these
you know, if you're
phone
going to, has requirements for all prosecutors that, you know, if you're going to bring a tax prosecution, you have to consult with the tax division, right?
Correct.
If you're going to bring a national security related case for classified mishandling of classified documents, you need the National Security Division to okay that, right?
Correct.
And as it relates to, you know, sensitive political matters, the Attorney General has to okay, and there's been a series of memos both from Attorney General Barr and Garland and so forth, correct?
Sensitive political matters, I'm not sure if that's the terminology. There's an election year sensitivities memo, and there's also regulations, specific regulations for specific situations, yes.
Right, and the FBI calls it a sensitive investigative matter, and, you know, they need to get they can't do anything without getting the director of the FBI to okay, you know, getting search warrants against members of Congress and so forth, correct?
I'm not as familiar with the FBI regulations as the DOJ regulations.
But is public integrity, before you seek member toll records, is the hoop you have to jump through public integrity?
So it was for my office because I directed my staff to consult them anytime we were going to do that. I understand that that was more of a practice and tradition. It's since become a specific requirement after these toll records were issued, but it was my policy to do that, and it was, again, consistent with my policy of wanting to sort of leverage the expertise in the department. So we did that.
Is this back and forth, and your staff had a memo that it, I think, you know, basically put in email, and then public integrity responds with this message. Is that essentially the extent of the back and forth with public integrity?
I don't know that this is the extent of it. There's a line here that says, "As you are aware." That makes me think that there was also a telephone conversation, but I don't, just to be clear, I don't have a specific recollection of that. I told my staff that in this situation, if we're going to seek these toll records, you need to consult with public integrity. As you can see from the email chain, I wasn't on that email chain.
Were there any other boxes you had to check? Did you have to tell the Attorney General or the DAG to get these toll records, or was...
So that little spiral down there restores all your health and weapon power. I totally forgot about that. We're still talking about toll records. What the crap?
Was it just you and public integrity?
My direction was to tell for our staff to go to public integrity. It may well have been that this is the sort of thing either I would have briefed the Attorney General on, or J.P. Cooney, who was our contact with the leadership of the department, may have told them about. But the thing that I was most concerned about was making sure public integrity, who was sort of the experts on this issue, that they were consulted.
I mean, this isn't, if you look at the email, it's not that fulsome, right? It's not a complete analysis of the constitutionality or even the propriety of the call record subpoenas under the speech or debate clause. I mean, is that fair to say?
Yes, certainly there could be more analysis, but again, I don't know if there was an additional conversation that it seemed, I'm drawing an inference, I don't recall this, but this seems to me to indicate there may have been an additional conversation.
So the email, you know, from our perspective, it seems to be a cursory litigation risk assessment. It's not, you know, it doesn't raise the issues that we would raise if we were litigating the speech or debate matter. Because, I mean, our position is that the toll record subpoenas do violate speech or debate. I mean, if you get a list of all the people calling members of the Judiciary Committee before a floor vote, that is pretty core protected material. You know, this back and forth with public integrity doesn't address very much. Is that fair?
Well, again, I don't know if there were additional conversation or conversations. I also don't know, frankly, if this is the only email on this issue. So I don't think I would call it cursory. I think an important context here is that the people involved in this, including the people on this email chain, as well as one of my senior counselors, Ray Hulser, who was really the department's expert on these issues, that these are people with expertise in this area discussing it with one another.
But if you believe what the Washington Post reporters wrote in their book, they say, according to their sources, that you were legendary for being dialed into, every last detail of these cases. That you were, they stopped short of calling you a micromanager, but they say that, you looked at, witness outlines, 2 days before witness interviews. Is that fair?
I did that with outlines of interviews, yes.
And you had, at points, you had daily meetings with the teams, and you wanted to know, every last detail of your case. Is that fair?
I try to be a responsible supervisor, yes.
But when it comes to taking the members of Congress, phone records, you weren't as plugged into that. Is that fair?
No, I don't think that's fair. I spoke with my staff about this. I ultimately approved it.
Right.
I had faith in the expertise of my staff. They discussed it with me. I felt there was a basis for it. I felt it was relevant and material to the investigation. And I also felt comfortable because I knew that my view about that would be tested by an analysis of public integrity.
Well, look at the last sentence. Low likelihood that any of the members listed below would be charged, and the litigation risk would be minimal. Not to mention, they're not going to know. So the assessment is, as Steve described, pretty cursory.
I think that's Jim Jordan. What a waste of sack of person. I mean, that's a waste of water, honestly.
We're not going to charge anyone. We're not going to get sued. They're not going to know. Who cares about speech or debate? That's what the assessment looks like to me. Your response?
Chairman, I would disagree with that characterization of it.
Well, that's what the sentence says. We're not going to charge these people. I doubt if they take us to court. It'd be hard for them to take us to court because they're not going to know for years that we did this. Move ahead. And you said fine to that.
I approve these subpoenas, yes.
Okay.
And, our view is this is inconsistent with the D.C. Circuit case law, which establishes that the speech or debate protections includes a non-disclosure privilege, period. It's not just a privilege against using that material against the members. It's also a privilege against taking that information and using it against a third party. If you're going to prosecute Jeff Clark with Scott Perry's phone records, we believe that the D.C. Circuit holds you can't do that. And this back and forth with public integrity doesn't factor that in. That's concerning to us. Did you have any discussions with the Office of Legal Counsel or the Solicitor General's office? Were there any other components in the Justice Department that analyzed this?
On this discrete issue, I don't have any recollection of those entities being involved in that discussion.
Okay. And there's a statute regarding Senate phone records. Are you familiar with 2 United States Code 6628?
Yes.
And did you analyze or factor in that statute before you issued the subpoenas for the senator toll records?
As I sit here today, I don't recall specifically discussing that statute. I will say that my reading of that statute as it existed at that time is that was a statute directed at providers. It actually envisions that a provider might actually get an NDO application, and the provider who has the best information about whose phone line is whose, that they're best situated to make these judgments.
Okay, so that was my next question, is like, whose responsibility it is to flag that there's a statute, a law, that bars NDOs with regards to certain Senate phone numbers? Whose responsibility? Is that the special counsel's office? Is that the carrier? Is that the judge? Does the judge have to sort of figure this out? The magistrate judge? Certainly the magistrate judge doesn't have to figure it out like all on his own, does he?
Well, that statute, as I said, my reading of that statute, the language of that statute as it existed at that time, is that it's the job of the carrier, and to me that makes sense because they're the ones who have the best and most accurate information about whose phone lines are whose. They actually have that information.
Okay. But the package of materials that you send off to the magistrate judge or the chief judge, whoever the duty judge, as you mentioned, you don't identify that it's a Senate phone number or a member of Congress in those applications. So there'd be no way for the judge to to know that there's these additional considerations. Is that fair?
I think that is fair. I think the department guidance on that issue has changed since these events we're talking about. And so now if one were to do that, you would notify the judge.
Okay, and my time's up, so unfortunately I have to leave it there. We'll go off the record.
With AI,
You can create any character you want in seconds.
this used to require huge Hollywood
Off the record.
Trump left the office in 2021 with these highly classified. Mr. Smith, let's just start with the bottom line up front. One of your investigations focused on whether any person violated the law in connection with efforts to interfere in the lawful transfer of power following the 2020 election. Is that correct?
Yes.
At the conclusion of that investigation related to the interference in the lawful transfer of power following the 2020 election, when your office indicted Mr. Trump for his criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
For these charges stemming from Mr. Trump's criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to prove these charges beyond a reasonable doubt?
Yes.
And we know that it's more than just a reasonable doubt. Did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump after he attempted to criminally overturn the 2020 election?
I did.
Now, the second investigation that you were appointed to lead focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. When your office indicted Mr. Trump for willfully keeping highly classified docs after he lost the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
And for these charges stemming from when Mr. Trump left the office in 2021 with these highly classified documents, did you believe that you had sufficient evidence to prove the charges beyond a reasonable doubt?
Yes.
And did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump for his unlawful possession of these highly classified documents?
I did.
How many years of experience do you have as a prosecutor, Mr. Smith?
In total, I've been a prosecutor a little short of 30 years.
And can you give us a high-level overview of the different offices you might have worked in as a prosecutor?
Sure. I started my career as an assistant district attorney at the Manhattan District Attorney's Office in New York City. I prosecuted local crimes there for 5 years. Afterwards, I became a federal prosecutor in the Eastern District of New York, which is in Brooklyn and Long Island. And I was there for about 9 years. I prosecuted larger, more complex cases when I was there. I was eventually the chief of criminal litigation there. I left that office to go overseas and work at the International Criminal Court for a little short of 2 years. I coordinated investigations of the Office of the Prosecutor there. I then returned to the Department of Justice, where I was the chief of the Public Integrity section of the Department of Justice, and I did that for somewhere between 4.5 and 5 years. I left Washington, D.C. and moved to Nashville, Tennessee, where I was the first assistant U.S. attorney and then later the acting U.S. attorney in the Middle District of Tennessee, which is in Nashville.
So now we're talking about his extensive experience as a
left
prosecutor.
government for the only time in my career. I was worked for a private company for a brief period of time, a period of months, and then I was offered a position by the State Department to serve as a war crimes prosecutor at a European Union war crimes tribunal in The Hague, the Netherlands, and I was there for a little over 4 years before I became special counsel.
I'm sorry to interrupt. Can you just speak up a little bit?
Oh, I'm
I know-
sorry.
Yeah, the people in the back have trouble hearing you.
Sorry about that.
And can you describe the types of cases out of all these years of experience? Just give us a broad overview of the seriousness of the cases that you've brought in your career.
I've worked on all sorts of cases. Early in my career, I was a member of the offices in Manhattan, the domestic violence unit, and so I did a number of cases of people who are abusing domestic violence victims. Those are some of the most memorable cases in my career. I worked on gang cases, RICO gang cases, in the Eastern District of New York. I worked on the Admiral Louima case, which was a assault of a Haitian immigrant by police officers. I did other international, an international murder for hire case, other sorts of violent crime cases. I was one of the night of 9/11, I was part of the command center, and in the weeks afterwards, I was involved in responding to what happened
I think I got
on
footage on
9/11.
that one.
After the Eastern District of New York, when I was overseas, I worked on war crimes cases that were in all sorts of different jurisdictions and all sorts of challenging investigative situations. And political corruption cases, obviously, when I was in public integrity and also in Nashville.
So taking all these cases you described, I heard cases about, gangs in New York, it sounds like. There were war crimes cases, there were domestic violence cases you just described. Taking all that experience, when you finished your investigation in the special counsel's office, you believed that you had sufficient evidence in this case to prove Donald Trump committed those crimes after the 2020 election?
I did.
And you believe that you had enough evidence to get a conviction with Donald Trump taking or willfully taking the classified documents after he left office in 2020 and returned to Florida in 2021?
That's correct.
So we've heard a word a lot from this administration, from the majority Republicans, and that word is transparency. And yet, Mr. Smith, we're in a closed-door deposition today, meaning that members of the public and even congressional members and staff who are not part of the Judiciary Committee are not permitted to attend this proceeding. Did you offer to testify publicly before this committee?
Yes.
How did you offer? I guess, how did you make the offer to testify publicly to this committee?
I think it was through my counsel.
Did you send a letter to the committee? Did your counsel send a letter to the committee offering to publicly testify?
I think that's right.
We'll enter that letter into the record just for your background. And this will be Exhibit 7. It'll be an October 23rd, 2025 letter signed by Mr. Lanny Brewer and Mr. Peter Koski. It's addressed to Chairman Jordan and Chairman Grassley regarding Mr. Smith's public offer to testify publicly. Are you familiar with this letter, Mr. Smith?
Just out of curiosity, I want to see if fire does anything.
Yes.
Sometimes.
Can you tell us why you felt it was important to make a request for a public hearing?
I'm proud of the work that we did at the special counsel's office. I'm particularly proud of the people I work with, the career public servants I worked with, who've been vilified by President Trump and the people who work for him, and I think someone needs to speak up for them.
Did you want to testify publicly because you had something to hide about your investigation?
No.
Did you want to testify publicly to rebut some of these accusations from the president that you just mentioned about your investigation?
Yes, that's what I meant. Accusations not just against me, but against career prosecutors, career FBI agents who have served our country and who've been vilified wrongly. I think it's really important to correct the record on that.
Were you granted the request to testify publicly before this committee? The answer's probably obvious as we sit in this room, but were you granted that request?
No.
Were you given any reasons or provided any reasons why you were not allowed to testify publicly and directly to the American people?
I don't recall that.
Are you aware that even President Trump thought that you should testify publicly before our committee?
I heard that.
Yeah, just to make it clear for the record, Mr. Trump said, and this is a quote, "I'd rather see him," as in Jack Smith, "testify publicly because there's no way he can answer the questions." So let's turn to a few of those questions. Do you recall the October 14th, 2025 letter to you from Chairman Jordan requesting a transcribed interview?
I know he sent a letter asking for me to be interviewed, yes.
We'll enter that into the record and make it Exhibit 8.
Thank you.
And I'll give you a second just to look through it as we pass it out.
Trump is a joke. A dangerous joke. It's still a joke.
So in this October letter to you requesting a transcribed interview, the chairman characterized your investigation as, quote, politically motivated prosecutions of Donald J. Trump, end quote, and said you conducted a, quote, unnecessary and abusive raid of the residence, end quote, of Donald Trump, and that claimed that you, quote, manipulated key evidence in the investigation, end quote, among other claims. Do you recall these accusations to you in the letter from Chairman Jordan?
Yes.
The Republicans of our committee have made these letters to you public. You can read it on the committee's website, including these accusations that your office was weaponized. But this proceeding is behind closed doors, and Majority Counsel just warned you earlier about keeping the contents of this deposition confidential. Do you remember that warning that you received at the beginning of this deposition?
Yes.
So we will get into this in more detail later, but just to quickly touch on this, do you agree with the majority's characterization that your office was weaponized?
No.
Was your special counsel's office weaponized in any way?
No.
Did you conduct a politically motivated prosecution of Donald J. Trump?
I did not.
Would you like to have explained directly to the American people why these characterizations are not true?
Yes, and again, particularly as to the career prosecutors and agents who've been vilified.
Are you concerned that given that this deposition is not open to the public and the public cannot hear your answers or observe your demeanor or hear the way that you're responding to questions from the majority, that some of your responses may be selectively published or released in a way that mischaracterizes your answers?
I would hope that wouldn't happen.
But are you aware that's a risk of your testimony here today?
I'm sure that's possible.
Based upon your knowledge, is it generally the practice for the special counsel who investigated presidential conduct to be given the chance to testify at a public hearing to be able to explain their findings to the American public?
Yes.
So let's just take a few of those. Are you aware of special counsel Robert Mueller testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in July of 2019. Are you aware of special counsel John Durham testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in June of 2023. Are you aware of special counsel Robert Hur, who came up earlier in the majority's hour, testifying before the House Judiciary Committee?
Yes.
For the record, that occurred in March of 2024. Also want to touch a little bit on, speaking of just transparency and a fulsome investigation into this committee's request for documents related to your investigation. We're going to enter into the record another letter from Chairman Jordan. This one's addressed to Attorney General Bondi. This letter seeks records related to the Arctic frost files, and it's dated October 29th of 2025. This will be Exhibit 9. And you might not be familiar with this document, so I'll give you a second to review it. It's not very long, though.
And you'll teleport out before the ice things even hit you. Yeah, it worked. Good. It's a good little tip.
Okay,
This one just said get good with the bombs.
So after reviewing it, are you now aware that Chairman Jordan has sought the production of files related to your investigation from the Department of Justice?
Yes.
And just to read that request, it's request number 2. It says, in quotes, all DOJ documents and communications referring or relating to Jack Smith's special counsel investigation for the period of November 18th, 2022 to January 20th of 2025. I just want to get a better understanding of this broad request of all DOJ documents and communications referring to your investigation. I guess what types or categories of documents are associated or would be associated with your investigative files?
No lives linked.
There would be numerous documents. I mean, it was a prosecutor's office, so the sort of documents you would associate with a prosecutor's office.
Just to make it clear for the record, can you just give a few examples of what those records or memos might look like or what they might be about?
Prosecution memos, email correspondence with my staff, analysis of the case, things of that nature.
Would these documents include internal decision memos or other records of major decisions made by you and your team during the investigation?
Yes.
Do these files include communications with the Attorney General or the Deputy Attorney General during the course of your investigation?
I don't think I had any files that would fall into that category. I'm not sure if there'd be, my deputy also communicated with the Deputy Attorney General's office, so there may be, but I don't think that's to me.
Do these files include communications just with other DOJ offices? I think earlier you mentioned possible communications with the Solicitor General. Would those files include possible communications with that person?
Yes.
Can I just follow up on that for 1 second?
Sure.
You had no communications with the Deputy Attorney General?
No, I took the question to mean in terms of like email or things of that nature. We met, I met with the Attorney General, the Deputy Attorney General, at times at their request. So those things did happen. I'm just saying I don't recall me having any sort of email communications with either of them.
But in terms of the special counsel offices, just following up Mr. Golden's question, the office as a whole, if there were email communications between members of your team and the Attorney General or the Deputy Attorney General, would that probably be a part of your special counsel case files?
Yes.
And as far as you're aware, the current Department of Justice has full access to your documents and memos and files from your investigation, is that correct?
They should.
In fact, you reviewed those files in preparation for your appearance today, right?
Yes, we were given access to a computer that had files on it. I can't say that it's all the files, but we were given access to that, and I reviewed that in preparation of today.
Did you follow DOJ protocol in your decision-making, including consulting with relevant offices like the Public Integrity Section, the Office of Legal Counsel, and any other entities as required and encouraged by DOJ policy?
Yes.
Were there examples where these consultations were memorialized in writing, either before or after you met with these offices?
Yes.
So given the majority's claim that the investigation was biased, do you think the case files would help eliminate some of the majority's questions about the actions you took while special counsel?
I have no objection to people looking at the case file.
To your knowledge, has DOJ released all the special counsel's files, either to Congress or to the public?
I don't know what they've released to Congress.
Do you believe it's in the public's best interest to view the full case file rather than just selective samples as they've come out so far?
The reason I'm pausing is I'm not sure it's proper for me to weigh in on that. I don't know if there are, for example, confidential information regarding witnesses that shouldn't be made public. And so I think that's a matter for others besides me who have the case files in their possession now to review and decide.
So let's just narrow it a little bit. Do you think it would be beneficial for the committee to review the case files so we can understand why certain investigative steps were taken?
I'm going to leave that to others to decide. I'm here and I'm happy to answer any questions you or anybody else might have.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened?
It never happened.
I use PayPal to buy this ticket. I'm paying it off over time. No fees, no interest.
You know what else has no interest? Me.
You can pay your own way.
Excuse me, sir?
Yeah.
The captain needs you back in the cockpit.
Oh, yeah, sir.
What?
One hit.
I also just note the authorization that you got from DOJ, and I think this is marked as Exhibit 2. Exhibit 3 by the majority. It was quite broad, right?
Which one is this now?
This is Exhibit 3, a letter from the Department of Justice to your counsel.
Yeah. Stop getting hit.
I have my own copy. Apologize, we've got a lot of letters here, so.
Just don't have a lot of evidence.
Oh, what a cheat.
That's been disclosed.
Okay, I have the letter now,
Okay,
yes.
so I'm looking at page 3 on the bottom, but this letter essentially walks through a series of topics that you are authorized by the DOJ to discuss.
Correct.
So on the bottom of page 3,
You just don't have a lot of evidence. I mean, shut your mouth, you punk ass, whoever said that. If you're not going to be there and take this crap seriously, if you're just going to throw one-off statements out.
I'm reading here from the letter. The extraordinary events underlying this matter constitute exceptional circumstances warranting an extraordinary accommodation to Congress in this particular case. Given these extraordinary circumstances, to the greatest extent allowable by law, the Department authorizes Mr. Smith to provide unrestricted testimony to the committee, irrespective of potential privilege, including the names of line attorneys and agents in the Department as it pertains to the matter identified in this letter, and as limited in paragraph 1 through 5. And the paragraph 1 through 5 essentially goes through the investigations that you undertook and I guess a couple of tangential matters related to the Office of Professional Responsibility and the Arctic Frost investigation. Is that correct?
That's what that says, yes.
Okay. So given that DOJ gave you unrestricted or authorization to provide unrestricted testimony, would it make sense that DOJ then should also give this committee unrestricted access to the case files that's currently in its possession?
I'll leave it to others to decide that. I will say that the paragraph you read is different than it's been with past special counsel. Past special counsel usually testify about the contours of their report. They've changed the process here, and I'm still here willing to answer questions.
Okay, thank you.
We're gonna, I believe we're on Exhibit 10 now. We're gonna Exhibit 10, which will be your special counsel report, Volume 1, dated January 7th of 2025. I know this is a document. I know this is a document you're very familiar with, but we'll pass it around. So as the date of your report says, on January 7th of 2025, and as your time as special counsel was coming to an end, you provided a final report to the Attorney General where you explained the prosecution and declination decisions that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this...
Okay, so that puts us at 145. And we beat Mega Man 1. And so far, as far as the special counsel report goes, we've heard some GOP guys whine and moan and go on about the fact that few of them might have been somewhat sort of investigated for possibly, conspiring to overturn a free and fair election in our country. And yeah, that's been about it. And now they're starting to just kind of go through all of Jack Smith's procedures and everything else. I mean, I think the most interesting part was just his initial statement there at the beginning, where he kind of laid out the fact that they had a lot of evidence, and a lot of their evidence was going to be other Republicans. Okay, so next time, shoot, we'll make it Mega Man 2. Might as well. We'll just make our way through until we have gotten through all this. But anyway, till next time, guys.